All right, there we go. And we are live. So, good evening, everyone. It is Mary, the host of the Singles Oasis. So, we want to welcome you for our live segment titled Singles and Succession Planning. I don't know about you, but I am so excited because I have a special guest, and our special guest is the one and only attorney Ernscie Augustin. So, hi, Ernscie.
Hi, everyone.
So, really quickly before I introduce Ernscie, just a couple of things. I just want to remind everyone the foundational scripture for the Singles Oasis: where there is no counsel, the people fail, but in the multitude of counselors, there is safety. I also want to remind our singles that wisdom is the principal thing. So, therefore, get wisdom, and with all that getting, get an understanding. So, singles, again, this is our special segment dedicated to succession planning. Singles, we need to get our affairs in order. So, let's talk about succession planning. So, this is not a conversation that you should put on the back burner. So, again, I am the host of the Singles Oasis. Before I turn the floor over to Ernscie and before we start our dialogue about succession planning and estate planning and the like, I just want to put out a little disclaimer. So the conversation that Ernscie and I are having tonight is for informational purposes only. So this conversation does not constitute, nor does it create an attorney-client relationship between attorney Ernscie Augustin, between attorney Mary Bowen, and between the Augustine law offices. So again, this is just an informational segment. So please do not construe this segment as neither one of us giving anyone legal advice tonight. So now that we have that out of the way, I want to take a moment to have our guest introduce herself. I would have her read her bio, but instead, I'm just going to save her the trouble of me reading her bio. And Ernscie, why don't you tell our audience who you are, what you do? So just tell us a little bit about you.
Hi, everyone. First off, I want to thank you, Mary, for the introduction and for the invitation to your lovely podcast. I had the opportunity to watch some of the previous streams, and it's very informational and educational, and I really appreciate what you're doing in the community. So it's amazing, and I'm happy to be here. So as Mary said, my name is Ernscie Augustine. I went to Michigan State for undergrad and law school. I practice law here in East Lansing, Michigan, but we do practice statewide. So as Mary had the disclaimer earlier, I don't practice in other states. So if you are watching in another state, just keep that in mind. I practice estate planning, probate litigation, estate administration, and also family law, which includes divorce law. So I'm happy to be here and excited to get started.
Awesome. So before we dive into more of our questions, Ernscie, what made you choose estate planning as a practice area? I mean, did you go to law school specifically for that particular practice area, or did you have something else in mind?
Well, it's funny that you asked because I didn't really think about estate planning when I was in law school. I wanted to practice family law, which is funny because I do practice family law now. But after my first year in law school, I interned at the Ingham County Probate Court. And that gave me exposure to estate planning, administration, and probate litigation. And I loved it. So I spent my summer there visiting wards, aka people that have guardians and conservators. So we would go to their house and do evaluations, or to the facility where they're at, and we would then present the report to the probate judges. And so I really loved it. And I thought, you know what, it would be amazing if you could do probate and family law, because I could see the overlap even when I was in law school. And I was blessed enough to start at a probate firm after law school, and they did estate planning and elder law and Medicaid. And so when we started the practice, still practicing those same areas. So I like to say we work with families, whether it's individuals or collectively, and it's just awesome to be able to see the connection between the two areas and the overlap. So,
oh, that's awesome. So, speaking of estate planning, like, what exactly is estate planning? Like, what does that mean?
Okay, so estate planning involves a variety of legal documents One is a will. I'm sure many of you probably have heard of a will, trust, medical and financial power of attorneys, deeds. So they're pretty much legal documents where you're instructing your loved ones or the court, the public, on how you want your assets to be distributed, but also who do you want to name in charge of your affairs if you become incapacitated or after you pass away. But also with the trust, for example, you can manage that while you're alive. So there's different things that an estate plan can do and different benefits for you. But essentially, it gives people instructions on what to do, the people that you name to be in charge.
Awesome. So should we wait until we get older to think about estate planning? Like, when is the right time to think about it?
That's a great question, because there is this misconception that individuals that are older should think about estate planning, or individuals that are rich. So there is this misconception that some people think, I'm not rich, so therefore I don't need a will. But no, once you become an adult, there are benefits to getting a power of attorney, for example. We're near Michigan State, and I'm like, a 20-year-old could benefit from having a power of attorney, because technically, once you reach the age of adulthood, no one could really make medical and financial decisions for you if you become incapacitated. Now, you may see that there are institutions that are lenient, but legally, that really shouldn't be happening. Again, people may be lenient in some of these other spaces where if you don't have a power of attorney, then they may still allow your parent to come in and make decisions for you. But as we know, everyone doesn't get along with their family members. So, as you could imagine, that some of these, when you think about doctors and nurses, there's a liability aspect to allowing a random family member to make big decisions. So if you're not married, for example, there's benefits to having a power of attorney, even more benefits to that, because you don't want them to assume that sister or mom or dad should be the one making those decisions, especially if you don't have a relationship with them, or they may just not be the best person to be making that decision.
Okay. So I just have a general question, just for myself. I kind of have an idea, based on my background, but do property law and probate law, how do they intersect?
So probate law, one thing I do love about probate is that you get to dabble into other practice areas. Even if you're not practicing those areas, you get to learn more about those areas. So for example, real estate, right? When we're dealing with probate, going through either through probate court or drafting a deed, we're dealing with real property. And so you will find that a lot of probate lawyers have knowledge about real estate law because of the work that we do in terms of funding a trust, for example, or administering the estate. So we definitely, there's definitely overlap. We have to be educated in those areas. Another thing that we also do going through the estate process is get properties listed and retain realtors to get those properties listed and sold, and the proceeds distributed to beneficiaries. So there are definitely overlaps there as well.
Okay, let's talk about some of the terminology you may have mentioned, a few minutes ago, just for clarity for purposes of the audience. So you mentioned something about a will. What's a will?
So a will is a legal document, kind of like how I explained it earlier. It provides instructions to your loved ones, to the court, as to what you want to happen after you're gone. So if I sign a will today, it doesn't necessarily mean that the personal representative, so the personal representative is the person that's in charge, AKA executor. I know sometimes people call them executors, but the personal representative is the individual that you name to be in charge of your estate. You can name several individuals in order. You could say, for example, if I say I want to name 3 personal representatives, I can name my mom first. If something happens to her, she's unable. Number 2, I want to name my father. Number 3, I want to name my sister. That's an example. But they can't do anything with that will in terms of like acting in their role, right? They're not going to put on the hat until after I've passed away. Right? So once I pass away, then they can start acting as personal representative, but it's usually they have to go through the probate court. in order to get their letters of authority to begin acting as personal representative. So that's the purpose of a will. You can name beneficiaries in your will. Who do you want to be in charge? What do you want to happen to your personal property? But a will doesn't avoid probate court. So that's just something to put out there. And people assume that a will avoids probate court, and it doesn't. There are obviously benefits to having a will, but it's really a trust that avoids probate.
Because I've seen, in some instances, where wills are challenged, whether the person that, subject of that will, they're questioning their capacity. So was the will made in duress? Did they have the capacity? Were they incapacitated, at the time? Was there undue influence? Like I've seen, challenges, made to wills, and we may, depending on how much time we have, we may discuss that, a little bit later. I've heard of something called a pour over will, and I'm not really familiar with that. What is a pour over will?
So a pour over will actually goes in line with having a trust. So essentially what you're saying is that let's say if I forgot to fund my trust, put something in a particular asset into my trust, the pour over will references the trust. So for example, if I have a pour over will, the beneficiary section can say, Ernscie Augustin revocable trust. Mm-hmm. So it puts the reader on notice that there is a trust. The trust and the will go together, right? And so that's anytime you see a pour over will, you're likely going to make the right assumption that there is a trust. They go together. They go hand in hand. And what we're essentially saying is that, hey, if I forgot to put a particular account in there, I want to provide this to the probate court so they could know that we need this asset to pour into the trust.
Okay, wow, I did not know that. So okay, here's the thing. So you mentioned it. So are pour over wills common then? Sounds like they are. But.
Yeah, they are common, especially for individuals that end up getting trust agreements. But if you don't have a trust, then you can just get the will. It wouldn't be a pour over will. You just get a will. It doesn't have to be a pour. So we usually do the pour over will when a person or a couple, an individual or a couple ends up getting a trust agreement.
And speaking of a will in general, does a will have to be filed anywhere? For example, does it have to be filed with, the Register of Deeds, or does it have to be filed with the court? I'm not clear about that.
Yeah, not necessarily. I mean, some people do. And for example, I think it's like $30 or $40, probably less than whatever county you're in. Every county is different in terms of their probate court. But if you don't, for example, if I sign a will today and I don't record it, with the probate court, that doesn't necessarily mean that the will isn't properly executed. But when it's time to open an estate, we have to say, hey, there's a will, and we record the will with the probate court when we're submitting the application to open the estate or the petition.
Okay. So you mentioned the trust a few moments ago in terms of the pour over will accompanying a trust, in terms of assets that might not have been originally included in a trust. But what is a trust?
So a trust is also a legal document that explains and provides instructions as to what you want to happen to your assets. Now, the difference is a trust does avoid probate. Let's say I create a trust now. You remember earlier I said if I create a will and I name my mom, dad, or sister, they can't necessarily do anything with it because I'm still alive, right? But whereas a trust, I can create a trust and start acting as trustee of my trust. While I'm alive, I can still manage assets and transfer to my trust, manage them as trustee. If I step down or I'm unable or I become incapacitated, my mom could step up as successor trustee and continue managing it while I'm alive. So that's another benefit of having a trust, is that you can manage assets while you're alive. Whereas a will, you can't necessarily do that because it's pretty much saying after I'm gone, that's when the personal representative could, start acting. Whereas a trust, you could put terms in it's a lot more broad. You could say, this is what I want to happen during my lifetime, and this is what I want to happen after I've died, right? So a trust creates a lot of flexibility in that sense. I know, and we call them trustees. The person that's that you name to be in charge will be a trustee.
Mhm.
Where will the person you name to be in charge will be a personal representative. And I know that, a lot of people think that they should get a trust. There are definitely benefits to getting a trust. I don't think that one size fits all. Like I don't have that. I don't have that type of practice where I say everyone needs to get a trust when they come through the door, because I don't think it's a good fit for everyone. But there are definitely benefits. But if you have a will, there's just ways that you can set up your assets where it could avoid probate.
Before I have you kind of talk about the difference between the two, you kind of alluded to that in terms of those that will, that are responsible for, I guess, I don't want to say executing, but in terms of following those instructions that are left by, whether it's the devisee, excuse me, the devisee or the settlor. I believe those are the common terms that are used. Pardon our legalese, everybody. But let's just say hypothetically, if someone were thinking about whether it's a will or a trust, and they would like to maybe meet with an attorney to, kind of talk about these things, are there things that they should maybe bring to, your office or to an attorney's office if they're looking to possibly have those documents drafted and or executed?
Yeah, that's a great question. We have an estate planning questionnaire that we send to a client once they book an appointment. And we typically say, if you can send it to us the day before your appointment, that would be great, about 24 hours in advance. But sometimes clients come in with the questionnaire. That's totally fine as well. And this questionnaire essentially asks for, information. And you may think that it's not important as a client. You definitely want to make sure you're filling it out. And parts that are not relevant, you can leave blank or cross out and just tell the attorney that. But the reason why it's important is because the attorney used this information to gauge as to what type of estate plan that you should get. So in general information like, your name, date of birth, children, grandchildren, assets. So where are your properties? Do you have any real properties, life insurance policies, investment accounts, bank accounts? Do you have beneficiaries' name? Who are those beneficiaries, right? So it's pretty, and it's lengthy, but it really gives the attorney information to properly advise you. So, and we also say, if you have any documentation that you would like to attach, like any deeds, any lien, mortgages, things like that, attach it. I usually tell clients, if you don't know, I would rather you just bring it to the meeting, because I would rather you bring more than not bring enough. And then we draft something and it's like, hold on, we didn't know that, this particular asset existed. So the fun thing about sending out those questionnaires is clients usually come in, they're like, I hadn't thought about this particular asset in years. Like this questionnaire makes me think about, what do I really own? What are the balances? What do I need to update? So it's a great refresher, but that's usually the information that we have them complete. And then when they come in, or they have it when they come in, we advise from there.
Awesome. And see, I like that, because that's not something, ordinarily, even I would think about, because I would imagine that there's things that, that I would leave out, or, because it's not right in front of my face, of course, I may forget about it. So that's a good tip. So everybody keep that in mind, if you're thinking about setting up some type of estate plan and there's a questionnaire that you need to fill out, that'll serve as an important reminder of items that you want to bring to, the attorney, and things that you would want to disclose. So I want to get back to, the will versus a trust. So I guess what's the difference between the two? You kind of alluded to it, but just in case, some folks in our audience have a question, like I still don't quite know the difference between the two. I have a general understanding, but I need to know the distinction.
Okay. So one of the biggest distinctions is that a will doesn't avoid probate. So if I pass away with a will, then my whoever I name, right, as personal representative, have to go through the probate process. A trust, it doesn't go through the probate process. Now, there are exceptions to that, especially if we end up in litigation. But generally speaking, a trust it avoids probate. So this means that, for example, if I do a trust and it avoids probate,
Mm-hmm.
it's not open to the public, right? No one really knows that I have a trust besides those beneficiaries and the trustee and the individuals that are required to get notice. Whereas a will, another difference is the privacy component. Um,
Mm-hmm.
once the estate is open, that will is recorded with the probate court, or it could be recorded prior to my passing. So the will is open to the public. Now, I don't think that the average person is like, I really want to know what Ernscie's will says, or John Doe's will says. It's really not that interesting to most people. But people do think about that. If you think about celebrities, I'm sure that many
Mm-hmm.
of them would prefer to have, a trust. Um, but that's really the biggest difference. A trust, when you get a trust set up, I like to say it's like an empty pot, right? It's like a pot, and you have to fund it. That means you have to transfer assets into the trust. Right? So getting the trust set up isn't the only thing you have to do. You have to actually add assets to it. So let's say I create a trust today. All I did was create the trust. If I didn't move assets in there, then what's the benefit of that, right? So I'll have to do a new deed because I want to add my house to the trust. So
Mm-hmm.
my new deed would say Ernscie Augustin Revocable Trust, or something like that, so that now my real estate is part of is part of the trust. So we call that the funding process. And so when we prepare a trust for a client, an individual, we give them a memo. It's like a packet that
Mm-hmm.
assets and say, this is how you have to transfer it. We handle the deed for them because real estate is is a big asset. The last thing we want is for someone to make a mistake. We hand them the deed and then they forget to take it to the register of deeds, or things happen. So we end up recording the deed. So if the person has property, we do the deed for them. We record it with the register of deed. Once it's recorded, we give it back to the client. But besides that, if you want to fund, let's say, for example, if I want to add my bank account
Mm-hmm.
to the trust, let's say I'm with, Bank of America. What I can do is I can add the trust as a beneficiary to that account,
Mm-hmm.
or retitle the account from my individual name to the trust, right? So Ernscie Augustine, Revocable Trust, Bank of America. I don't know what the title would be because every bank is different. Every institution is different as to how they title them on the actual statement. But that's another thing, right? You can make your trust the beneficiary of certain assets. So that's really the biggest difference. Again, I don't tell everyone that they need to get a trust. It really depends on that questionnaire, which is,
Mm-hmm.
I usually tell people, hey, you definitely want to complete the questionnaire. And if you don't complete it, at least during the meeting, we're going to talk about it. I usually take notes and say, okay, what are your assets? I make sure that they break it down if they didn't complete the questionnaire. And we go through that together because that's going to determine whether I advise that you get a trust or not.
Okay. Okay. So I think you mentioned irrevocable, an irrevocable trust. So I've heard those terms, used interchangeably. So what's the difference between a revocable trust and an irrevocable trust?
So the revocable trust is something that I could change, I could amend, I can move property out of it as well, like move assets out. Whereas an irrevocable one means that you can't do. It's not as flexible, which is the reason why I rarely do them because it's not as flexible, right? So
Right.
the revocable one, pretty much, you relinquish your control over those particular assets once you put it in the trust that you can't revoke. So I don't generally do those because, I mean, to relinquish control over your assets, it is a big deal. Um,
Mm-hmm.
and so that's really the difference. Most of the trusts that I do are revocable. So you could come back later and amend. You could come back later and say, I want to move something out of trust, so long as you have capacity. So I know that we didn't touch on that yet. Maybe it will come later, but when you get an estate plan done, right, you're
Mm-hmm.
of sound mind. Um, like if you end up, let's say you end up subject to a conservatorship or guardianship, right? There's usually a capacity issue
Mm-hmm.
that
Mm-hmm.
change it, right? Or someone has, they're diagnosed with dementia. Now you want to change it, you can't come back and change it, right? Because now it's an issue for, like, do you know and understand what you're doing? right? And even coming in, do you know and understand the nature of your assets, right? Are you
Mm-hmm.
in the term undue influence? So estate plans could be challenged, and undue influence or lack of capacity, like those type of arguments are made when it comes to challenging estate plans. So to do our best to protect the integrity of the estate plan, as practitioners, we check for capacity, we assess capacity, right? We also make sure that the client, we're meeting one-on-one with the client. This is what you really want.
Mm-hmm.
So as long as you have capacity and you're like, hey, I want to come change it, amend it years from now, then you could make that amendment.
Okay. Okay. So you mentioned earlier, like kind of in the beginning where you were describing like the different components of an estate plan, you mentioned, powers of attorney. So what is a durable power of attorney?
So a power of attorney, so people say durable power of attorney. Sometimes you'll hear people say patient advocate. Patient advocate, also known as medical power of attorney. So there's medical power of attorney, and then there's financial power of attorney. And so medical power of attorney is a legal document where you say, this is what I want to happen if I end up, in a coma, or if I end up with a medical emergency, and this is the people that I want to name. Individuals, I usually tell people name 2 or 3 in order, because if you name one person and something happens to that person, now you have a power of attorney that, you just don't want it to end up in probate if you don't have anyone to
Right.
step. So I usually say try to name at least 2 people, 2 or 3 people.
Right.
But a medical power of attorney, this is, we call the person we name in charge an agent. So let's say, for example, I have a medical power of attorney. I say, Mary Bowen, I'm going to name her as my first agent. So you're my first agent. My sister's my second agent. My dad is my third agent. Now I have 3 people. If something happens to Mary, she's unable to, at least I have a second person that could step up. This is usually why I tell people name 2 or 3 people. Because what you don't want to happen is you create one and something happens to the person you named a year from now, and then now they're like, hey, who should make medical decisions for this individual?
Right.
You can take it back to square one, right? So in the state of Michigan, we usually say 2 doctors have to verify that you're unable to make your own medical decisions before your agent can step in, right? Whereas financial power of attorney, you can put that language, or we do it where, hey, you know what? Even if I have capacity, like my agent could make a financial decision for me under the financial power of attorney. The reason why I drafted that way is because if I have an emergency, right, the last thing I want my agent to run into is I need to go get a bunch of doctor statements. And I can't even pay her mortgage, or I can't even pay her car. I can't even, right, make financial decisions. And usually when you're making financial decisions, you're under pressure. And there's these deadlines and due dates for these bills that need to be. And so for financial power of attorney, we call them agents as well. Usually I advise clients when they get one done, especially if they're up there in age, it doesn't hurt to provide one to your medical care provider. Let them know that you have a power of attorney. And they usually ask that in the questionnaire when you set up a doctor's appointment. They usually have a box to say, hey, do you have a power of attorney? They want to know for a reason, right? Because this is the individual you're going to name to make medical decisions. When I talk to clients about medical and financial power of attorney, so they're both different. One is for medical, one is for financial decision. And, whether you have kids or not, name someone that you believe could actually do the job well.
Yes.
It is a lot of work. But, I like to use the example as, if you know that the person that you want to name for medical doesn't, do well when it comes to visiting hospitals or talking to doctors, you might not want to name that person, right? Some people they don't have the personality to make those medical decisions. And it is a hard decision to make, especially if your loved one is in a coma or has been in an accident. Do you think this person would be stable enough to make those medical decisions for you? Right. So sometimes I have clients tell me, well, that person is way too emotional. Let me put them on the financial side rather than the medical side.
Right.
Because if it is a big emergency situation, this person is going to have to communicate with the doctors, the nursing homes, the nurses, and are they going to be able to, withhold that? That's a lot of pressure. And for the financial, right? I usually say, name someone that you think is responsible with finances. And you wouldn't want to name someone that has like a gambling problem, right? So it's like,
right. Or
okay.
can't balance a checkbook.
Right. So name someone that is going to do the right thing and keep people informed. And again, these roles that I'm talking about, agent under power of attorney, trustee under the trust, personal representative under the will, they all have a legal obligation to act, right? They have duties that they must fulfill. So if they do abuse them, they could be sued, right? So that will go into probate litigation. But if they do try to, steal money from your account and it comes to someone's attention, they could be sued as power of attorney, right? So you want to name someone that you trust would actually do the right thing, would step up, right? And so, sometimes I have clients that say, well, I'm going to name my daughter medical power of attorney because she lives 10 minutes away. That's a good reason. Or my daughter's already a nurse, so yeah, she understands. Or my son, he's an accountant, right? Like, but they don't have to have those careers to do the right thing. Also, if that person you name has questions, they could hire a lawyer. So that's another thing. A lawyer could represent the power of attorney to help them fulfill their duties.
Wow.
You also want to name someone that is confident enough to say, I don't know what I'm doing, or I need help, so that they can reach out to a professional so they can make sure that they're fulfilling their duties. We represent trustees as well. We represent power of attorneys as well, right? When they need to do their annual accountings and get their finances together. Or sometimes if the medical power of attorney, they call us sometimes and say, hey, we're running into issues with this hospital. Okay, put me on the phone with the doctor, right? It's one of those things where sometimes you do have to push back and say, I'm power of attorney. I don't know what I'm doing, or this particular institution is giving me a hard time. So the attorney could represent me as the agent.
Okay.
That.
I'm learning so much new stuff right here. I'm trying to tell you, like, you could tell that this is just fascinating to me. This is like so fascinating to me. I mean, I'll put it like this. It didn't really capture my attention, in law school, but just now as we're, talking about this and having a conversation about this is really interesting. It's also putting some of the case law that I have read. It puts a lot of it in context now. So that's something to think about. And I just tell this, to my audience, like when you're thinking about, your those power of attorney documents, really think about who is responsible, who would be integritous enough to carry out that responsibility as your agent for your financial power of attorney, and who is cool, calm, and collected and can make a difficult medical decision on your behalf, as your healthcare advocate, because they may have to make decisions that might be a life or death decision. I believe I've seen some durable power of attorney documents where a decision has to be made as to whether the person is going to be made comfortable or that person is going to remain, on life support. I mean, these are the types of things that you have to consider if you decide to serve as someone's medical power of attorney, or consider the financial responsibilities and potential ramifications if you are choosing to serve as someone's financial power of attorney, because again, a lot of responsibility will weigh on your shoulders.
Absolutely.
Ernscie, why is it important for like me, you, other singles? Why is it important for us to have powers of attorney? Why is it important?
Well, it's important because you want to have the choice, right? To say, this is who I'm naming to make medical and financial decisions for me, right? And I do power of attorneys for married couples as well. And I tell them, what if something happens to the both of you? Right? That happens sometimes too. The couple is in a car accident. It's like, who's going to make decisions, right? So you want to be able to make that choice. A power of attorney also avoids probate. Generally speaking, if you have a power of attorney, then if something does happen, your loved one doesn't have to go through the probate court to get a conservatorship or a guardianship. So let's say, for example, if I end up in a coma, right? Legally, my parents can't just come in and start making medical decisions for me. I mentioned earlier, there's some places that are lenient, right? I've had people tell me, well, Ernscie, I didn't have power of attorney. They let me do X, Y, and Z. Well, you understand that could put that hospital or that medical facility in some legal trouble if something would happen, right?
Yeah.
So my parents can't just come in. What they would have to do, my parents or my sibling, they would have to file a petition for guardianship or conservatorship, because now I'm unable to make my own medical and financial decisions because I didn't have a power of attorney. So power of attorneys generally avoid probate. There's sometimes where we still litigate cases where there's a power of attorney, and we'll talk about that later. But generally speaking, a power of attorney also avoids probate, like a trust avoids probate.
Okay. So we talked about this the other day, while we were at the pool. We were talking about, people cutting corners. People are going to Home Depot and they're purchasing these form documents that, would serve as estate planning documents. I've even seen instances of this, when I was previously in private practice, where individuals are, maybe obtaining some forms, these generic forms, off the internet. And, some people balk at, I really don't want to retain an attorney. I really don't want to contact an attorney. I don't really want to spend the money on having an attorney draft my will when I can go grab something from, a retail store and, I can just fill in the blanks, or I can just look and see what's on the internet and use some type of quasi legal, search engine, and then whatever yields, I can just piecemeal and put this together. So I say all this to say, Ernscie, you know me, I'm just going to be blunt with it. Why should we not use these forms? Why do we have to be careful about cutting corners? Why?
I that's a great question, Mary. I've seen it. I know you've seen it. I've seen it as well. And sometimes people think that they're saving money up front, but it's going to cost you thousands later, right? Because now if you go and buy a deed or print one offline and you execute it without any legal advice, right? No attorney reviewing it to even, say whether your wishes are being fulfilled through this generic form, right? These places that you're printing them off online on these websites or buying them from these stores, they're not giving you legal advice. You could lose your house, right? These are big things that there are major consequences to signing documents that you don't fully understand, which is why it is better to pay an attorney to do it, right? Rather than, because what happens is if that particular document isn't executed well and you're alive and you're trying to get it fixed, now it's going to cost more to try to undo that mistake. Now, if you pass away and then your beneficiaries find out that there was a mistake, that can end up in litigation. Right. So now your estate is spending thousands. If there's, money in the estate to even pay this lawyer, now you're in litigation. It's going to cost you way more after the fact rather than, what's a few hundred. I tell people what's a few $100s to a house. Right. Most people, the house is their major asset. Right. What's a few $100s to get an attorney to do a deed rather than you go do it yourself? You sign the wrong thing and either lose your house or ends up in litigation. Even if you win in litigation, you've already spent thousands of dollars having an attorney on both sides, right, arguing as to the validity of the document that you decided to print offline. I usually say a deed is one of the riskiest things to do on your own because, I've seen that. I had a client some years ago and she got a deed. I didn't even know some of these stores sell deeds, but she got a deed for like $20, signed it with her son and got it recorded for her house that she worked hard all her life to pay. And she's a single individual, worked hard all her life, paid off this house. She's living in the house with her son. And what she really wanted was to say, this deed says if something happens to me, then 100% goes to my son. Vice versa, if something happens to my son, 100% goes to me. But the deed that she signed says we're 50-50%. We're 50-50 in terms of ownership. And that's not what she wanted to do, but she didn't have a lawyer review this. So the son ends up passing away and guess who comes in and say, I'm entitled to his 50%? His new spouse, right? Now, mom can't say, oh, it was supposed to, really, it was supposed to go back to mom 100%. But that didn't happen. That ended up in litigation. Now she's fighting for her 50%, and she's not even in the house. New spouse is in the house. New spouse was living with them. All three of them were living together. But mom moves out and say, you know what, I want to give them their space, right? They're newlyweds. Just for later, this new spouse is like, well, 50% is mine, and I'm not going anywhere. The 50% that was part of husband's estate went to her, when it really 100% should have went back to mom, because that's what mom wanted. Mistake is a hard legal argument to make, right? It's a hard legal defense to make. When you're in court, well, they didn't know what they were doing. That's why they did it. That's a hard legal position to take, right? But they end up in litigation. They're fighting over the 50%. And so now you purchase something for $20. You could have spent a few $100s, right? If she had an initial consultation with the attorney, she would have told the attorney. The attorney would have said, well, so what do you want to happen to your house? Well, this is what I want. I want, if something happened to him, it comes to me, vice versa. The attorney would have said, all right, I know what kind of deed you need to get. But the deed she got on her own said something completely different. So now you're spending thousands and thousands on a lawyer to fight to get your 50% back from new spouse. And again, mistake is not a good legal argument, right? So I just say you could lose your house, or you could lose interest in your house because you're trying to save rather than save up the money. I'm not saying nothing for everyone, but save it up, do the questionnaire, tell the attorney, this is what I want. In this scenario, this is how I want it to play out. And the attorney could do the deed for you.
Folks, that right there is a classic example of why you should not cut corners. Because imagine spending your whole life working to pay off your house, and to save a few bucks, you use some type of generic form which may or may not conform to Michigan law. It may not have the correct, phraseology, because do you want to have a tenancy in common with someone versus a right of survivorship? I mean, these are some important terms that you need to be familiar with, before you execute these types of documents. Hence the reason why you should talk to an attorney, because they can explain what these terms mean and what the consequences of these terms are if this particular language is in a deed.
You're absolutely right about that. It really made me think about, how I said mistake is not really a strong argument to make in court. Well, morality isn't really a strong argument either, right? That's a sad case. But it being sad doesn't mean that, right, she all of a sudden wins. And so, right, now we're trying to negotiate with new spouse, like, hey, just give her the 50%. She'll, buy each other out something, right? Some kind of compromise, some kind of middle ground. And she resisted. And so morally, some people that are watching this may say, well, that's so wrong, right? Wrong and illegal or legal are they're different things, right? So I can't necessarily tell, well, you know what, Your Honor, this is morally wrong what new spouse is doing, right? That's not a grounds for me to win. And so you want to keep that in mind, is that sometimes, especially, in general, in our society, we say, well, that thing is wrong. Wrong, illegal, and legal, they're not the same thing. The law is the law. And if you go out and buy something and you execute it, right, it's not like I could have argued she didn't have capacity, because she knew what she was doing, right? So there are so many corners that people try to cut. But I would say, when it comes to your house, really try your best to not cut corners with that. And she was, I think, in her 60s, 70s. You worked all your life. This is the only property you had, and you paid it off. And now this person says, hey, I'm entitled. The spouse is saying she's entitled, and she's not going anywhere. And you don't want to end up in that situation, because even if you win, now you've spent thousands on an attorney to get you to that win, rather than a couple of $100s at the beginning to get that deed done for you.
Wow. Because I always question, because I know that these documents, they do exist, and there's some services that claim that these documents purport to, a particular, state's law. And I often, call into question, is that actually true? Like, and again, I don't want you to get in a situation of, where you're giving legal advice, but I guess what my main concern would be is, do these documents even comport with, since we're in Michigan, do they comport with our filing requirements? Because I know the Register of Deeds, they're very particular about deeds being filed. Like, are the margins the correct size? Do you have the right font? Do you have the correct legal description? I mean, you don't even want to find yourself in a situation where, you might clog up or your title, you might cause an encumbrance on the title. Like,
you're 100% right on that, Mary. I had a case years ago and tried to do it himself, print them offline. I'm not even sure where he got it from. A bunch of deeds to deed his property. He had like rental properties, had over 10 rental properties, printed them off offline, signing them himself, and sends them to the Register of Deeds. Register of Deeds rejects the deeds because, like you said, they're very particular, right? They have these rules about the margins and everything else. So if you didn't do that, it gets rejected, right? But at one point in between that time, he talks to the attorney. The attorney said, I am willing to do the deeds and your entire estate plan that goes with the deeds. But he wanted to go do it he went to, take cutting corners. I'm just going to print them offline, sign them, send them to the Register of Deeds. They get rejected. By the time it comes to him, right, he sits on it for several months and then he ends up passing. So now, now we're in court trying to get these deeds to be, admitted. It's just so costly. He passes away before he could even correct the situation. And so you just never know, right? Life is short, but it costs thousands of dollars to try to fix those issues rather than, why not just had to have that attorney at the time just do them, especially with that many properties. But, my point is, if the Register of Deeds sends them back, that was already a sign. Hey, they're not recorded. They're not accurate. And he got them offline. Who knows what website he got them from? But he just printed a bunch of deeds offline and it wasn't recorded. So, and you're right. I've seen websites where, it's unclear what state, those websites are connected to. They'll just say, hey, you just do a quick Google search and this would apply to X amount of states. And it's like, how do you know? How do you know that? How do you trust? It goes back to what I said earlier. Like most of us, right? We spend all our lives working hard and creating, creating and trying to build security, and just to lose it because we didn't want to do our due diligence. It is shocking, but knowledge is power, which is why I say kudos to you for having this podcast, because you're educating the community and as to what they should do, whether that's estate planning or medical. Kudos to you for doing that, because now people are going to know, like, hey, it is better just to talk to someone. And you know what I like to say as well, let's just have an initial consultation. It doesn't hurt to even do that, right? Like the guy said, you know what, this attorney, if he would have taken those deeds that got rejected to an attorney, the attorney could say, you know what, those aren't recorded, right? Those don't conform with Michigan law. Even an hour or two conversation could have pulled him out of that, right? So even if it's a situation where you're like, I can't retain an attorney right now, but I could have a consultation with one on my desires, at least I can know what my next steps are in a few more months here.
And, folks, Attorney Augustin just, reiterated the importance of why we should not cut corners as singles. I mean, we are very sensitive that the times now are different. We know that, folks have to tighten down their belts, but please do not put your property at risk. Don't even consider getting a generic will or a trust offline. I should say online. Don't even do that. Like, please meet with someone that is competent and that has experience in this particular practice area at a minimum for a consultation, before you make that next step, because it could cost you more in the long run. You don't want to get tied up in litigation, and what you don't want is, you really don't want your beneficiaries to be adversely affected by the decision you made to cut corners, because it is costly to correct these types of mistakes. Remember, singles, we're trying to provide you with wisdom, because I know that this is an area that may not interest as many people. This is an area that may give people pause. But again, we're trying to give you some insight on what you should be thinking about and why you should get your things in order. You don't want to wait until something happens to think about this. Let's be proactive when it comes to our succession planning. So, Ernscie, you mentioned something earlier about, guardianships and conservatorships. So what exactly is a guardian, and when does a guardian come into play?
So there are a couple of types of guardianships. There's guardianships for developmentally disabled individuals. That's a petition that could also be filed. And then there's guardianships for incapacitated adults. And then there's also guardian for minors. So you have guardians for adults and guardians for minors. So we talk about guardianship, you're dealing with the probate court. So let's say, something happens to me and someone needs to make medical decisions on my behalf. I don't have a medical power of attorney. Then it's probably my mom or my dad or my sister who would file a petition for guardianship. So a guardian manages medical affairs. So they're petitioning the court to be appointed guardian to make medical decisions on my behalf. So you can go through a court hearing, right? You file the petition and you go through a court hearing. So, and then usually a guardian ad litem is appointed to investigate, but the judge will sign an order appointing this individual to be my guardian to make medical decisions for me. Whereas a conservator, there's conservatorships for adults as well, and minors. They're slightly different processes, right? They both call it conservators, but conservator for a minor, conservator for an adult. Conservatorship means that you have to petition the court. There's a court hearing, and investigator, guardian ad litem, is usually appointed. And when the judge signs an order saying that this person is my conservator, that means that this person could make financial decisions on my behalf. And when you complete the petition, whether that's the petition for the guardian or a petition for a conservator, it's a form, and there's usually a section as to why does this person need a guardian or conservator? Is it mental illness? Is it mental deficiency? Is it physical infirmities? Those type of things. So it's a guide to for you to know what exactly does the court want to know before I'm appointed to make medical or financial decisions for this individual. But you have to go through the probate court to get those things in place.
Wow. So in this instance, because you've explained the differences, between the guardianship and the conservatorship, but why are guardianships and conservatorships important?
So guardianships and conservatorships are important, especially if you don't have a medical financial power of attorney. I'll say this, it's more in terms of like legal work, and I'm sure there may be attorneys that are watching this, and perhaps they would agree. It's more expensive to go through the court process than to get a power of attorney. So when I mentioned earlier that a power of attorney avoids probate, that's another reason why it's better just to get the power of attorney. It's less expensive than now you have to hire a lawyer to go to court, right? Now, with that being said, there are people that file a petition for guardianship and conservatorship that are unrepresented, right? It happens. But a guardian is to make medical decisions, placement decisions as well. They can make placement decisions like move to a facility, home, things like that. And then the conservator is to manage your finances, and it's a court order, right? So power of attorney, the court isn't involved in that, right? You're getting it done with the attorney. They're drafting it, executing it with you. Power of attorney is not part of the probate court. Conservatorship and guardian, there's exceptions to that. Like I said earlier, if it's in litigation, then those power of attorneys could be admitted. But conservatorship and guardianship, you have to go through the probate court in order to get those things done.
Okay. if you see me, turning my head every so often, I'm just taking notes because I'm like, I'm just so, I'm so enthused, and it like just, I'm just really blown away about, some of this information because, I only have a basic understanding because again, this has not been my practice area, but these are just some things that are helpful.
Yeah, and to your point, when you made a point earlier about going to court, a guardian and a conservator also has duties.
Mm-hmm.
So I mentioned earlier that the trustee, when it comes to the trust, the personal representative, when it comes to the will, the agent, when it comes to the power of attorney, they have duties. But a conservator and a guardian also have duties. When you're appointed by the probate court, there are requirements that you have to do. So that's a difference as well. Right? If I'm conservator, I usually have to do annual accountings to the court. So it's court supervision when you get a guardianship and conservatorship. Power of attorney doesn't have court supervision, right? Okay. But a guardian and conservator has duties that they have to meet annually, right? Because in all those documents, you're filing them with the court annually, right? So in some ways, some people would say that's more work, right? Because now you have to notice the court and notice the interested parties. At a power of attorney, you don't have to do all that with the court, and the court could reject your accounting if you don't do it right. So this is, why I mentioned earlier, in any hat that you're wearing, whether you're a power of attorney, personal representative, trustee, conservator, guardian, you could be represented by an attorney. Right? So we have clients now, we're representing them in their, what we call fiduciary role. So all of the names that I just gave you, it could all be summed up fiduciary. Fiduciary is the person that's in charge, right? So fiduciaries can hire an attorney to represent them for them to make sure that they're fulfilling their requirements. Because if you're not, whether it's intentional or not, right? If you're abusing your power or you're messing up on docket, you could be removed by the court, right? So someone could file a petition and say, well, Ernscie's my mom's conservator. It's been 1.5 years. She hasn't done any accountings. We don't know what's going on with the money. And now there's a hearing as to my suitability. Should I be removed and somebody else gets appointed instead? So in all of these roles, you're wearing a hat, and you can hire to help, have someone help. You don't have to just do it by yourself, especially if you're confused on the duties, which is a lot, I think, when it comes to accountings. It's a lot of work for sure. So just keep that in mind, that you don't have to walk it alone. Like if you don't have to help you, because sometimes that happens too, where the person that's wearing the hat, the family's not really helping them, and they're carrying all the weight on their own, and they need help. So they'll talk to other professionals to help them, CPAs, right? They'll talk to someone to help them do the taxes annually, or retain a probate lawyer to make sure that they're submitting those reports on time to the court so that they don't get in trouble. So I just wanted to point that out.
I'm glad you brought that up, because that's something that we don't think about. Again, just some of the cases that I've seen, in terms of litigation, I've seen the extreme cases where, where a trustee has been removed, or a conservator, has been removed because, there's been a breach of some of their fiduciary duties. But in this instance, this is also singles why it is so important, if you're serving in a fiduciary capacity and you have questions, please seek out the professionals that have, the knowledge and the wherewithal in these particular areas. So if you need a CPA to help you with the accounting, hire the CPA. If you need a lawyer to advise you about your responsibilities under the law, hire a probate attorney. I mean, we're not just putting this out here just to put this out here. But again, this is just something that you can put in your toolbox. Like, consider the conversation, that we're having, the different things that we're talking about. Consider this as, a way to put some helpful resources and tools into your toolbox, regardless of where you are in life. Just think about these things. So we're talking about, we've kind of gotten to the point of, like, court, like when things are actually gotten to the point where, we're at court. So there's some type of litigation involved. There's some type of probate litigation that has been instituted. So, and you've mentioned some ways in which we can protect our assets from being probated. So, having having, having the trust, for example, having a power of an attorney so the court doesn't have to appoint, a guardianship or a conservator. But let me ask you this, Ernscie. So when thinking about estate planning, because I have some singles, in my audience, that are single parents. So for those singles that have children, can they have an estate plan created, with their children in mind? And if so, how so?
Yeah, you can. Obviously, you can name your children as beneficiaries. You could also name who you would want to be guardian or conservator for your minor children as well. That could get tricky if the other parent is involved, right? Meaning the other parent shows up and they're like, "Hey, my parental rights haven't been terminated. I should be guardian and conservator." Okay, so just keep that in mind. But you can still name who you would want to be guardian and conservator for your minor children. If something were to happen to you in your will, you could also name them as beneficiaries. Now, if something were to happen to you and then your child, for example, right, you're saying, I want to leave my house for my child. If you put something like that in your will, you pass away, your child's like 12 years old, right? They're going to need a conservator to help manage that because they haven't reached the age of majority to be able to inherit that particular asset. So this is why I say you could name who you want to be guardian or conservator for the minor child. Or another example, where we had a case where, dad died and left money for the minor children through a policy, but one of the children was like 14, right? It hasn't reached the age of majority. So the insurance company didn't release the funds to mom. The insurance company sent mom a letter and said, the only way we're going to release it is if you give us a court order showing that you're the conservator for this minor child, right? So, which is her child, but she ends up getting a conservatorship to be conservator for her minor child, and the funds she deposits the funds into a restricted account, right? And it requires probate court supervision, right? So the funds could be released once the child turns 18, which is something I'd say that I appreciate about the probate court in the process, because, you don't want someone taking advantage of a minor child and taking their money, right? So it's like, okay, you haven't reached the age of majority. We're not releasing $50,000 to a 10-year-old, right? It's like, okay, but once you reach the age of the majority, I appreciate that the court has, the state of Michigan has that, where they're protecting the child's best interests, right? This should be used for the child, by the child, preferably by the child when the child reaches age of majority. The money I told you about earlier is put into a restricted account. That conservator can petition the court if they need to use some of the money. But I'll say this: there's an expectation that you should be the one taking care of your child. So if I leave $50,000, just giving you an example, if I have a partner and I pass away, I leave $50,000 for the 10-year-old. The $50,000 for the 10-year-old. I don't want you taking the money and using it, because who knows what you're doing with it. That's
exactly.
Secondly, it's like when the child turns 18, 19, I want them to have the $50,000 so they can say, hey, I want to go to college, I want to start a business, I want to go to trade school. Right. So there's an expectation. What would you be doing if you didn't have that money? Right. That's usually how the court looks at it. Like, I'm going to go spend all this money on all these other people. It's like, but that's the child's money. So if you have to petition the court to tap into those funds, you're going to have to explain as to why you need to tap into those funds before, and the court has to make a decision as to whether that's a valid reason or not. So they're protecting the child's best interests. And I appreciate that Michigan has, and a lot of states do have this, but I appreciate that the state of Michigan has that because they want to protect the child's inheritance.
I'm so glad that's in place. Like that mechanism is in place, because You just don't want to see an unfortunate case where, that $50,000 was used inappropriately, or that $50,000 has been exhausted by the time the child reaches the age of the majority. So I'm glad that those types of procedures, are in place. So with that being said, we talked about children. I just have one question about, the fur babies, about the cats, the dogs, whatever little pets, some singles, may have, because I know some of you out there are dog moms, cat moms, cat dads, cat moms, all of that, dog dads. I don't want to leave anybody out. But with that in mind, so can, singles make provisions for their pets in their estate plan?
They can, and typically through a trust. So like a pet trust to say, this is what I want to happen. If something happens to me, this is who I want to take care of my dog, for example.
Right.
So it's definitely something you can do, and something you should think about if you do have pets. And even if you don't have a pet trust, but think about, which family member or friend, or you can have a conversation while you're alive and of sound mind. Like I tell my sisters, if something happens to me, I know one of you can take care of my dog because they love my dog. I was like, if I didn't put it in writing, I'm pretty sure one of them was like my family. They love animals, so I'm like, someone's going to take care of it. I'm not even worried about it. But have those conversations. Like, okay, this is the person I would want to take care of my dog, and or even if you're incapacitated. So even if it's not a thing where you've passed away, let's just say if something were to happen to you, do you have someone that can stop at the house and pick up your dog or your cat or whatever pet that you have, that can take care of your pets temporarily until you get well and get better? Because sometimes that happens. A person will lose capacity, and then who knows what's going on with the pets at the house. That's not, that's unfortunate. Or they may not recover. And so who's going to, I don't think the average pet owner wants to say, oh, I'm just going to take my dog to a shelter. But if those things happen, it's always good to have people in mind that are willing to step in.
And I just thought of something, when you mentioned that, when you talked about, having someone step up in the event that the owner becomes temporarily incapacitated. I have seen cases where some pets were either taken to the Humane Society or they were taken to a shelter because their owner is moved into a nursing home or moved into assisted living where they don't allow pets. So I would imagine that this is also another instance to think about, who will keep your pet, in the event that, you are no longer able to stay in your home.
That's very true. And I think that, going back to our, this is part of estate planning as well. Like if there is someone that you trust, right, the person that you trust, letting them know that you do have an estate plan, right? Because I've had times where someone come in office, they're like, I know my mom had a will, but I have no idea where it's at. I don't know anything about, right? Like that's hard too. So, and mom didn't say where it was. So now they're looking through everywhere in the house. They're like, we've spent weeks even before coming to me, searching the house up and down. They're like, we don't see any evidence of a will. So I say, if you have someone you trust and you do get an estate plan, tell the person you trust, like, hey, I have an estate plan. So they could know, so that if there is an emergency, they're like, that's where I need to go get a copy of the power of attorney. So I could rush to the hospital and let the doctors know that I'm power of attorney, right? Somebody should know where it's at, right? So especially if you don't record it, which is part of the problem. But I think usually when an attorney prepares the estate plan, their contact information is on the estate plan. I've also found that, I've had people tell me, I know my mom had a will 20 years ago. I just have no idea where it's at. And it's like, well, it's almost as if you died without a will because nobody could find it.
Right.
Right. So it's one of those things where, like, if you have someone you trust, tell them that where it's at, or keep it in a safe, or keep it somewhere safe or in a safe, so that someone knows like this is where the will is, or this is where the power of attorney is.
Right. Wow, that's good information, and that's a good reminder. So, when would be an instance? Well, let me back up and say this: how often should an estate plan be updated?
It really varies. Like some attorneys say every 5 years. Some attorneys say based on like life changes. For example, if you've expanded your family, now you have a family,
Mm-hmm.
uh, or someone has passed away. Like if you've had several beneficiaries pass away, for example, or your spouse has passed away, divorce, right? So major life changes is usually what I tell people, and I say don't be afraid to revisit it. I think one of
Mm-hmm.
the things about estate planning that makes it hard for some people when we really think about it. People don't want to think about their own demise, right? That's usually why people avoid,
Yeah.
right, talking about estate planning. I mean, there are a lot of people come through and get estate plans, but you have a sector of the population that's like, I don't want to think if something bad happens to me, I don't want to think about it. No one really wants to talk about their demise, but that's one thing that we all know is going to happen, right? No one's going to live forever. So I tell people it's better to be over prepared than under prepared. It's better to have your desires in writing than for the court to have to make a decision as to who should be making those decisions for you. So, so yeah, to answer your question, which I already have answered your question, but I want people to keep that in mind.
Mm-hmm.
That it doesn't have to be a negative thing. You don't
Right.
have to say, I'm going to go with because something bad's going to happen to me. I'm going to pass away. It's like, no, it could be a positive. See it another way. See it the other way around. Like I'm telling people what I want. So if anything, that puts you in power. That puts you in control. Like see it from the other perspective. Not, oh, what if something happens to me? But hey, you know what? At least I put my wishes in writing so that if something happens to me, people know what needs to get done, rather than the court having to make that decision,
Right.
or so, because you're not there to testify. You're not there to say what is it that you want. Even if you are in a facility, like you mentioned earlier, right? Some people end up in nursing homes. Even if you're in a nursing home, what if you have dementia? So there's no, right? Usually you can't really say what you want. You're not able to really articulate it well because of your mental deficiency. So I see it more as, especially in this line of practice, because
Mm-hmm.
I like how you started off the segment about how I ended up in this practice area, because I tell people maybe I wouldn't be this way if I didn't have this much exposure, especially being a young adult, right? Because I
Right.
have people that say all the time, I'm not going to get it until I'm like in my 60s or my 70s. But I've had young people come through with emergencies as well. I've had
Mm-hmm.
those where I've had to go to court because somebody ended up in a car accident, right? So I say this to say, see it more as empowerment. I'm empowered to put my desires and my instructions in writing. This is what I need to happen, and I'm of sound mind. This is the decision that I'm making. If it needs to be updated, because I've had people come in and they've had an estate plan 10 years ago. I had a guy come in from 30 years ago. I had to do his. It's like, okay, the laws have clearly, a lot of it has changed, but
Right.
right, you could amend your trust 10 years from now, 15 years from now. But I usually say if it's a major, and when he came in, his wife had passed away. Right? That's a major life change. And so how do we, do you want to update your beneficiaries? What do you want to change? Even though he was keeping the same beneficiary because they only had 3 kids, but he knew like, I need to update some stuff because there was clearly things in her accounts that need to be transferred. But also like, now I need, talking to an attorney will open your eyes, right? Now he's like, now you're forcing me to think about some of the other things that assets I may have forgotten about because it was 30 years ago. So there's a lot of benefits in doing that. Um, I usually say as well, like, how some people, they have New Year resolution. It's okay to,
Yes.
skim through your estate plan once a year, right? It doesn't have to be every month. Like now you're panicking, something's happened to me. But it could be an annual thing where it's like, all right, let me get my papers organized. Let me make sure. Another thing, check your beneficiary designations, because I realize people forget those often.
Mm-hmm.
Like, oh, I opened that account 10 years ago. I don't remember who I made beneficiary.
And that's really important. And I'm going to get to that question in just a moment. But singles, I also want to remind you, because, you know, many of you have desires to leave an inheritance not only for your children, but your children's children. And having a good estate plan and state in effect, and in place, you know, that is a way for your assets to be, you know, pretty much gifted to or transferred to, you know, the next line, the next lineage, the next generation. So don't necessarily view estate planning as foreboding. Let's just say that it's not foreboding, but the purpose of it is to, um, again, have things in order, so you avoid the cost of your family having to go to court when you're not around and no one knows what your expressed wishes are. You have these documents that will specifically outline, you know, what your last wishes are, or what you want to see happen to, you know, your property and your various assets, you know, when you go on to be with the Lord. So please, 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 not only think about this, but get your affairs in order. So, Ernscie, you mentioned beneficiary, like designations. Like, what are those? And I guess, when do they come into play?
So a beneficiary designation or transfer on death designation, what transpires, like, let's say, for example, you open a bank account. You know, when you open a bank account, they give you a bunch of paperwork and they ask you, who do you want your beneficiaries to be on that form?
Yes.
A bunch of paperwork. And then when you look at the beneficiary designation, some people leave it blank and they forget that they've left it blank. Or some people, they'll add someone on the beneficiary form and then they forget, right? Most people aren't thinking every day, like, who's my beneficiary? So that happens. And what happens is when you name someone on the account as beneficiary, that avoids probate. So this is why we also say on the questionnaire, we want to know, what accounts do you have beneficiaries for? Because we want to talk to you about that at the initial consultation. So if that's something that you want to change, we're going to advise you, right? Like, we're going to say, hey, you need to go do that, rather than I do a will for you and you put someone different on the beneficiary designation that conflicts, right? So we want to make sure that those things align. So to decrease the likelihood that that would end up in probate court. But life insurance policy, right? You're putting beneficiaries. So when you think about the accounts, or even retirement accounts, you're putting beneficiaries down. So those are the beneficiary designation forms, and that's like a contract.
And with that being said, because I know you've talked about this, you know, alluded to, you know, matters going to probate, but I guess I've heard the term probate estate, and I don't want to assume that our audience is familiar with, you know, a probate estate, but what is a probate estate and what items are considered a part of the probate estate?
Yeah, so when we talk about estates, we're really talking about, and it's probate as well. So sometimes you'll hear people use them interchangeably. We're talking about your assets, right? So it's very similar to like a marital estate. Right? We talk about marital estate, you talk about married couples, their assets and debts and everything. So same thing with a similar thing to estate. So my estate consists of, right, house, bank account, right? It consists of personal property as well. So it's not just, you know, bank accounts, but when you think about your entire estate, assets, debts, liabilities, that's your estate. And, you know, we talked about the probate court earlier, and the probate court has oversight over those type of cases, whether it's estates, guardianships, conservatorships, and mental health proceedings as well.
Okay. So I know you briefly, you know, alluded to this, you know, in terms of why it's important to select, you know, a beneficiary designation, and why when you meet with an attorney, you need to let them know, you know, who your beneficiary designations, you know, are for these particular, I'll just say contracts. I'm not calling them contracts per se, but a lot of these like the bank accounts and the insurance policies and some of the retirement accounts, they are governed by a different area of law, and these items are not considered a part of the probate estate. But what happens if we do not designate a beneficiary on these types of accounts? What happens and there's no one named?
Yeah, if there's no one named, that account goes through the probate process. So I like giving examples. So for example, let's say I have 4 bank accounts and then 3 of them I name beneficiaries. That one account that I didn't name beneficiary is going to go through the probate process. So in order for your loved one to access that account, the bank, it really depends on the bank, but they either don't want to talk to you, or they say there's no beneficiaries on there, or you're not one of the beneficiaries. It really depends on who you talk to. But if there's no beneficiaries, what they're going to say is you need to go get letters of authority. What they really mean is you need to go to probate court.
Ouch.
You need to get letters of authority naming you personal representative in order to access this account, right? Because there's no beneficiaries, that account has to go through a probate process. So there are times where someone opens up a probate case just for one account, just for investment account. So even if everything else you have avoids probate, that one account could still go through the probate process. Sometimes it's the house, right? So this is why I tell people to check. Just make sure that you have someone named. If you don't have someone named, if you're planning to get a trust, talk to the estate planning attorney, right? Make sure you have that in your questionnaire, because imagine if that account has $100,000 in there. No one could access it, so it has to go through the probate process. Even if your other ones don't have to go through that process, now you have to open a case with the probate court. And what happens is when we open an estate, we have to publish notice to creditors. And we have to keep it for like about 4 months, right? The estate administration is what we call it, right? So after you pass away, now someone has to administer the estate. It's usually the personal representative. The personal representative is administering the estate. Not having beneficiaries is going to create more work. That's really what's happening, right? Because now that personal representative has to go to court for this 1 or 2 accounts, and the case has to stay open 4 to 6 something months. It really varies on the size of the state. Sometimes it can be open for a year, right? And all of that is just more work, more fees. And so towards the end, that's when the proceeds from the account can finally be distributed. But it goes through this series of process. I mean, there's creditors that can make claims against the estate. It's just, it is a lot to go through if you just happen to forget to put a beneficiary on there. So putting beneficiaries avoids probate.
So here's another thing then. So when should we update items that are not considered a part of the probate estate? So when should we update, those beneficiary designations on the bank accounts, the insurance policies, and those retirement accounts as singles? When should we do that?
I would say kind of like a life-changing event. I would say to change it. Like obviously, if you go through a divorce, and there's divorce laws, there's statutes. We're talking about probate and divorce. Go through a divorce, go and change. I mean, I don't think the average person that goes through a divorce would want to keep their ex as a beneficiary. But and I'm not judging you if you decide to, but you would want to change, update that beneficiary if that's your desire. If the beneficiary passes away. So let's say, for example, I have a bank account, Huntington Bank. And if I have my grandmother as the beneficiary, one person, she passes away. Now I forget that I need to go in the bank and actually add someone else. Now that she's passed away, she's no longer beneficiary, right?
Right.
So technically, you don't have a beneficiary on that account. It could still end up in probate. So if one of your beneficiaries pass away or several of them pass away, go in there and add new beneficiaries on the form or add contingent. Sometimes when you look at the form, it has contingent beneficiary sections as well. So if you want to keep that in mind, right? If somebody passes away and it's like, oh, I forgot that this person was my beneficiary. And then now that they've died, and then if something happens to me, now that account is sitting without beneficiaries, it still goes through the probate process. If you have a dispute, and I'm not telling you what to do, right? If you really have a dispute with someone, you're like, I don't like this person anymore. Okay, right? If it comes to your heart, I need to change the beneficiary. You need to do that, because you know what could happen is if something happens to you, that person inherits. Now you have family or other loved ones are like, that person wasn't supposed to get that money. My sister haven't talked to him in 10 years, right? It's like, it's going to go to them. But all of that could be, all of those issues could be remedied if you just go update it. When you get into this dispute, and I'm not saying you should automatically do it, but you have to, follow your own instinct and your heart. And another reason why we ask for disclosure on these things is because those two things could conflict, right? If you forget, right? If I put a good friend on my bank account, in 10 years or 5 years we don't talk, and then I go do a will and say, well, this bank account should go to my sister, those two things conflict. The beneficiary designation form says it goes to my friend, but my will says it should go to my sister. That could end up in litigation. Because now, right, and guess who's likely going to win under Michigan law? The friend. Yep. Because that was on the beneficiary designation form. So this is why we ask for the questionnaire to be completed. So that as we go through it with you, hey, you said you have your friend, is that what you want? Yep, that's what I want. Or no, actually, I don't want that anymore, right? So to be able to advise you, if a will conflicts with a beneficiary designation form, typically the beneficiary designation form will trump it.
Got it. Oh my goodness, Ernscie. We have talked about so much valuable information. And I don't know about you, but like I've definitely been blown away. I've definitely learned something new, and I definitely hope that our viewers have learned something new. We only have a couple more minutes left, so I want to make sure that if our audience, hypothetically, if anybody in their audience wants to discuss a potential estate plan with you, or if they have questions, how can they get in touch with you? How can they contact you?
So our office is Augustin Law Offices, so no E at the end of Augustine. And our number is 517-939-1880. So that's 517-939-1880. Feel free to give us a call, and we'll assist you.
I'm going to have you repeat that number one more time so I can make sure the banner scrolls down at the bottom. I couldn't type fast.
Our office number is 517-939-1880. That's 517-939-1880. And like I mentioned, we do estate planning. We do estate administration. So after the person has passed away and the estate needs to be administered, probate litigation. So if the cases do end up in court, and family law and elder law. So there's a lot of overlap in what we do. We work with families and individuals. Like I mentioned earlier, I do have single clients as well that come in and get estate planning documents. And we're always happy to help, and feel free to visit our website as well, AugustinLawOffices.com, and you'll find our practice areas are listed, and we define a lot of the key terms that I've defined today on our website as well for educational purposes. And you can also book via email, contact@AugustinLawOffices.com. That's also on our website. Or you could just give us a call at the 517-939-1880 number.
Awesome. Thank you so much, Ernscie. So just for our live audience, her contact information is scrolling at the bottom if you want to contact her law offices. So the 517-939-1880. And then also to the website in case you want to go to the website so you have more of an idea of Attorney Augustine's practice areas. Attorney Augustine, again, this has been a phenomenal conversation. We at the Singles Oasis, we are grateful for your time. Thank you for taking time out of your busy schedule to talk to our audience here at the Singles Oasis. We want to thank you for the conversation about singles and succession planning and the discussion on why it's important for us to get our affairs in order. Just for our viewers, I just want to remind our viewers, if you're not already, follow me, Mary Bowen, on Substack at substack.com /@Mary Bowen. My name is lowercase, so MaryBowen. There's no spaces. You can follow me on Facebook as well. Just look for my professional page, so Mary Bowen. I have a fancy updo with pearls and a suit. Don't forget to find the Singles Oasis. We have a YouTube page now. We are so excited about that. So you can follow the Singles Oasis on YouTube now. So our YouTube page is the Singles Oasis. So this video will be posted on our YouTube page, as well as my personal and my professional page. You can also look for the Singles Oasis on Instagram, and that's also at the Singles Oasis, all lowercase. So again, we want to thank you all for tuning in tonight. We definitely want to give a special thanks to Attorney Ernscie Augustin for the lovely discussion about estate planning. I mean, we just talked about kind of a wide variety of things, and this hopefully gave our audience an overview. So again, Ernscie, we want to thank you for your time tonight.
Thank you for the invitation, Mary. Keep up the great work. I really enjoyed this segment. Like I said, I watched some of the other ones that I found on the Facebook page, and this is great work that you're doing. Great for the community. I love how you post them as well, so people could go back and reference them on their free time. So thank you for the invitation. It's my pleasure to help such an awesome attorney as yourself as well.
Thank you. Thank you. You know what? Teamwork makes the dream work. And I'm so glad that you are a part of our legal profession. We are definitely so glad that you were willing to lend your knowledge and your time to the Singles Oasis. You are definitely, like I said, not only an asset to the legal profession, but you're also an asset to the Singles Oasis and our viewers tonight. And just as a reminder to our viewers, this will be posted. So this will be posted on all of the social media platforms that I have mentioned. I will make sure that this most recent broadcast is pinned on my professional page as well. And I will also make sure that Ernscie has access to the same. So Attorney Augustin, I'll make sure that you have access to this particular segment so you can share that on your law firm's page and other platforms as you so choose. So again, we want to thank you all for tuning in tonight. Feel free to reach out to Attorney Augustin if you have questions about estate planning. Feel free to reach out to me if you have suggestions on future topics for the Singles Oasis, or if you need special prayer, or if you'd like to give us any feedback, please feel free to shoot me a message on Facebook or on YouTube as well, or on Instagram. So again, we want to thank you. And this is the conclusion of our Singles and Succession Planning Live segment. So thank you all and have a great night.
Have a great night, everyone.